Alex Sparrow is back with me tonight. He's got a unique perspective on the case as a former Florida Circuit Court judge. He's, of course, also the host of television's Judge Alex. Well, Judge Alex, this is getting down to the real nitty-gritty now, isn't it?
Yes.
This animation video, I mean, it's pure propaganda, isn't it, for Zimmerman's case?
Absolutely. There's absolutely no reason that the defense or the prosecution would put in an animation that helps the other side. They are seeking to put in an animation that tells the story they believe happened. So for the prosecution to get in and say, well, you know, this doesn't have the parts that we think happened, well, of course it doesn't. If you create your own animation, you're not going to put in, you know, Trayvon beating up George Zimmerman, because that's the defense theory, not your theory. Still, I think it should come in as a demonstrative aid for them to use at closing, but not go back to the jury as evidence, because there are a lot of holes in it that have to be filled by the person creating the video, because some things haven't been testified to.
This evidence from Dr. Vincent DeMaio, on the face of it, could be crucial. He seemed very credible. He's obviously incredibly experienced. But there were holes in it that I thought the prosecution got into right at the end there very skillfully. Take it in totality. What did you think of it?
I thought it was devastating. I mean, I thought that this was an ME. The doctor we saw last week, the state's doctor, Dr. Bao, he was not the way that you're used to seeing medical examiners testify. Dr. DeMaio is not just a well-known. He is world-renowned. He is the guy who wrote the book on firearms, on firearm evidence. He's a great forensic pathologist, and you saw how he testified, and he hit all the key points. He talked about the powder tattoos, indicating that the shirt was 2 to 4 inches away from the body, consistent with George Zimmerman's testimony that Trayvon was leaning over him. I don't think it was necessary. I mean, up till now, we've heard the testimony of an eyewitness who said as much. Wet grass on the back of George Zimmerman, on the knees of Trayvon.
But hearing that from him,
in a
forensically saying, look, this world-renowned guy is saying, to me, this is consistent with what George Zimmerman said.
And he hit so many other things. He hit the key points about the absence of bruising on the knuckles, which to me was a big point. I've heard MEs testify about it. I knew it was coming.
He said it doesn't happen after you die, right?
Exactly. He said you lose blood pressure, the bruising does not occur. So that gave the defense something to argue to the jury about that. Now, the prosecution did get up and try to score points on him, but I really disagree that they scored points on him. Saying to the medical examiner, you don't know who threw the first punch, when you don't know who threw the first punch, is not very effective. The prosecution does not have one witness who says George threw the first punch.
Right, but nobody knows Florida law better than you. Is that not the big question? Because to win a successful self-defense argument, doesn't George Zimmerman have to have established in the jury's eyes that he was attacked first?
That's a good way to start, because if you're the attacker, then obviously you have a lot more to do in order to be able to claim self-defense. You have to withdraw, you have to try to back out. And remember, there is evidence that George threw the first punch from George's mouth. Okay, I mean that Trayvon threw the first punch from George's mouth. Now, obviously he's biased, he's on trial, but you need to have something to rebut that, and the prosecution does not. The real key issue is not who threw the first punch. The real key issue, and this is where the jury could convict George Zimmerman of manslaughter, the real key issue is when he's on his back, when Trayvon's on top of him, is he in a position where he fears for his life or for serious bodily injury?
Is that all that matters in the end?
At the end, that's all that matters.
Under Florida law, that's the moment.
Because
what happens before, after, really is irrelevant.
Not totally irrelevant, but that's the key point. Because if at that point he is in reasonable fear for his life, and that's where Dr. DeMaio helped him a lot by saying, look, these injuries, he should have gone to the hospital. The police could have been sued if he died in the police station. If a guy has and this was his quote, if a guy has the injuries that he had, you take him to the ER, because this little minor cuts on the back of his head are not dangerous, but they're indicative of a serious impact on the head, which could cause brain swelling, bleeding, and things like that. And that's the point the defense is going to make. They're going to say, how does George know? If his head's getting hit on the pavement, if his nose is getting broken, how does he know if the next hit is going to crack his skull? And that's what they're going to rely on. If the jury buys it, it's a not guilty because of self-defense. If they don't, it's a guilty of manslaughter. I just don't see second.
Judge Alex, thank you very much indeed.
Thank you.
When we come back,